All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Helvetica against GIRAUDO. Our cause number 1CA-CV 150490. Counsel, as I'm sure you're aware, we're quite familiar with the background of this case, having published on it several times and have read the briefing carefully and analyzed the law, so you can bear that in mind as you begin your presentations. You will be, we will all be audio and videotaped today, and the recording will be made available to the public online. Each side has 20 minutes for oral argument, and the appellant is free to reserve as much time as you wish, subject to watching your own clock. And with that, we can begin.
If it may please the court, I'm Dan Kloberdance on behalf of the appellant, Joseph GIRAUDO. And as this court is well aware, this aspects of this case have been up to the Court of Appeals and two other matters that resulted in published opinions, one involving the Barrel Michael Pasquan, which really has nothing to do with this case at all. The other one involves the redemption rights for an assignee of the borrowers in a case called Gold versus Pasquan, authored by you, Your Honor. And that is relevant to this case, specifically because in footnote 2 of that case, I'm not saying it's the law of the case, but it is a reported case that's the law in Arizona. This court specifically stated that when a debtor applies for a fair market value determination, as was done in this case, then ARS section 1566 applies for the redemption rights of junior creditors, which is exactly what we have here. And I'm going to talk about that in a little bit. On appeal, the sole issue for GIRAUDO's appeal is the correct redemption price. Judge McVeigh ruled that to redeem a junior creditor has to pay the full amount of the foreclosing lien. It's an obvious error. That should be the easiest decision this court makes this year. On the cross appeal, I'm going to spend very little time unless you have some questions. Judge Hanna had granted GIRAUDO's motion for summary judgment to get rid of this section 33-420 claim against GIRAUDO for having filed a wrongful intent to redeem. Helvetica also raised the MERS defense, MERS, which I've briefed that as well as I want to. Has no validity whatsoever, and I'd only direct this court's attention to the fact that in the actual deed of trust, the subject deed of trust in this matter, it states on page 1 that Joe GIRAUDO is the lender, and MERS is just a nominal beneficiary. The redemption statutes don't state anything about beneficiaries or anything alike. It talks about creditors, and a lender is a creditor. I'd also note that in Judge McVeigh's original ruling 6 years ago, Judge McVeigh ruled that Joe GIRAUDO does have the right to redeem. He just didn't think it was the right redemption price. So Judge McVeigh's already ruled that GIRAUDO has the right to redeem as a lender, but for paying the wrong price.
And how should we calculate the price?
The price should be based on the credit bid amount at the prevailing bid price, which is $400,000, plus by statute 8% as required by ARS 1285A. There were no additional. Sometimes you can add insurance and taxes and costs, but here there were no add-ons provided the sheriff. So it's quite simple: $400,000 plus 8%.
Well, that is the redemption price. Simple, but it doesn't really account for the statutory language. The language I believe you're relying on says that the redemption price should be calculated on the sales price. It doesn't say it shall be the sales price.
Well, it doesn't say, yes, if you get into, and let's talk about, ARS 1566 says the redemption price shall be calculated on the sales price of the real property. Let's look at, I think to answer your question, Your Honor, 1282C, which was what Judge McVeigh ruled, that talks about, subsection C talks about succeeding junior creditors who are redeeming. We'll give you an example, maybe best by example. Let's say you have a $1 million first, a $500,000 second, and a $500,000 third. And this goes to sale for $400,000. We use the same prices here. The senior junior creditor can redeem by paying, as stated in 1282C, may redeem by paying the amount for which the property was sold. That's the statutory language, Your Honor, for which the property was sold. So that's $400,000. And all liens prior to his own held by the person from whom redemption is made, it's talking about other creditors redeeming, together with 8% added to the amount as provided in 1285. So what that means is if you have a $1 million lien that's foreclosed, and that's bid, the credit bid is $400,000, it goes back to the senior lender. The next creditor in line can redeem by paying the amount the property was sold, $400,000, plus the 8%. The creditor below that creditor can redeem by paying the sales price plus the 8%, plus the amount owed to the second lien holder who was in front of him for $500,000, if that's what was owed. That's what that's talking about. It's a succession statute that applies only to junior creditors who are redeeming in succession. Right. So that's what that language means.
Doesn't apply here.
It doesn't apply here because there's no successor. There's no other redeeming parties. There's only one creditor attempting to redeem. Now, if there was a party in front of Joe Girardo who redeemed, then Girardo would have to pay that lien in full. But the problem with Judge McVeigh's ruling is, as this court cited the Kreis case, the Kreis case says that when the property's foreclosed, the debt is extinguished. There is no deed of trust anymore. That is, the creditor that forecloses takes the property, free and clear, everything else is extinguished, subject to the redemption rights. There is no deed of trust anymore because the deed of trust is foreclosed. It goes away. That's the reason for the bid. If you apply this logic if this is the law, then there's no reason to even have a credit bid for a lender. There's no incentive to the lender to bid the fair market value. You'd always want to lowball it because you wouldn't have to worry about being redeemed. Your Honor, as you stated in the Gold case, one of the reasons for these redemption statutes is to encourage and discourage low credit bids from being made, and that's exactly right, and that's what the Kreis case says as well.
Well, I'm not sure the Kreis case begins and ends with your citation, but let's start with the discouragement of low bids. In this case, the bid was well under the fair market value, right?
Right.
So if a subsequent creditor can redeem for an amount that reconciles the original lien with the fair market value, doesn't that also discourage lowball bids?
I'm not sure I follow your question.
Okay, fair enough. It probably wasn't very well stated.
No, it probably was. I just didn't understand it.
Yeah, I mean, the notion is we know this bid was a lowball bid because we know after the fair market value determination that there was more value than the bid encompassed. We also know that the original loan was probably undersecured because there wasn't enough fair market value.
Correct.
So your position seems to be the redemption price is the lowest possible redemption price, which is the lowball bid plus 8%. I gather that the appellee's position is it should be the highest possible price, which is the full value of the loan, and by lowballing we can actually create a profit through redemption. I don't see that either of those is really supported by the statutory language.
I would agree that the incentives is not in the statutory language necessarily. That's
but if
based on case law.
If we're concerned with the incentive, if we think that's the legislature's purpose, then we're not really violating that purpose by interpreting the statutes to require redemption at a price that reflects the fair market value, are we?
There's a lot of pros and cons either way, Your Honor. I would agree that the incentives
we're not
are
legislators. We're not here to consider pros and cons. We're here to consider the statutory language.
Let's look at the statutory language only. Let me focus on that. Let me also mention that in 1285B, which talks about the redemption price for junior creditors. And I'll read the second to last sentence. If the purchaser is also a creditor having a prior lien to that of the redemptioner, other than the judgment lien, the redemptioner shall pay, in addition, the amount of such creditor's lien with interest. So 1285 specifically excludes the judgment lien, the lien being foreclosed on.
Stop there, because I think you've hit on some critical statutory language. But what exactly is judgment lien? Because I'm not reading anything about Helvetica's lien to be consonant with the statutes that define judgment liens.
Well, judgment lien here is when you foreclose and you get an order, a judgment directing the sale directing the sheriff to go out and do a sale. That's a judgment. That's the judgment lien that's referenced in 1285. It's got to mean the lien being foreclosed on. Otherwise, this whole subsection.
It could also mean somebody who holds a judgment lien.
It could.
Which is not what we have here.
The monetary judgment.
The same rule. There's no statutory difference anywhere in these redemption statutes between a judgment lien that's being foreclosed or a deed of trust that's being foreclosed like a mortgage. There's no distinction.
Sure there is.
In the statutes.
Well, the statutes say, for example, that judgment liens don't apply to homestead property. This is a consensual lien that does apply to homestead property.
Yes.
And the Supreme Court has recently reaffirmed the need for strict construction of judgment lien statutes. I don't see that a foreclosed mortgage is the same thing as a judgment lien under any of the statutes that define judgment liens.
Your Honor, let me go back to 1256, which I think we all agree applies here in this case because the debtor did make a fair market value determination.
1566?
1566.
All right.
By definition, the statute does not apply to the credit bid. It does not apply to the debtor attempting to redeem. It only applies to junior creditors who are redeeming. If the talk about legislature again. If the legislature intended that the senior lien be paid in full, that the lien is being foreclosed on, then it would have been simple to say that the redemption price shall be calculated on the amount of the senior lien that was foreclosed on. It would simply say that, not to say that it's the sales price of the real property, which is the credit bid amount.
But that would then play into Helvetica's hands, which may also be an overly aggressive position, which is to say, I don't think the legislature intended that the senior lien be the price because it didn't say that. What it said is that it should be calculated on the sales price, but it didn't say exclusively. It didn't say shall be the sales price. It didn't say shall be the sales price, but plus 8%. If one reads all of these statutes together, including 1285B, it would seem that there is, in addition to the purchase price at auction, there is some other portion of the lien that must be paid. Now we have a situation that the statutes don't address it expressly, which is what happens when there was a fair market value determination.
Well, then we know. I think 1566 has to be read with the other statutes. I would agree with that.
Yeah.
Let me go back to the Christ case that specifically says after a judicial foreclosure, I'm quoting this, the redemptioner takes the property free of the debt. That's the debt that was foreclosed on. So the Supreme Court 1985 case in Christ says when the redemptioner takes free of the debt. So you don't have to pay the judgment because that's the purpose. That's the very purpose of the bidding process.
We're going in circles because the problem is the Christ case was talking about judgment liens.
Yes, and Your Honor, and I've said I don't see any distinguishment between judgment liens and mortgage foreclosures
what about
for purposes of redemption. There are differences. Obviously, there's differences.
So if there are differences, then the same words mean two different things?
I think the same rules apply to a deed of trust that's foreclosed judicially as to a judgment lien that's been foreclosed judicially for purposes of redemption. And you got to look at the priority. A lot of times when you foreclose on a judgment lien, it's not a senior lien; it's junior lien, and it could be a lot more complex.
I think Judge Brown had a question.
Okay.
No,
Yes.
I just wanted to go kind of maybe judgments 101 here, if you'd help me out. Who has the right to when do the rights of redemption occur? What gives rise to the right of redemption? Is there under these statutes?
The sheriff's sale itself.
Anytime that there's a sale, but on real property.
On real property.
Personal property.
We're talking about real property execution through a
Anytime
sheriff's
the sheriff
sale.
conducts a sale of any piece of property held by the debtor.
Right, not a non-judicial trustee sale, but a judicial foreclosure ordered by the court. Okay, I'd like to reserve the rest of the time, if I may, unless you have some questions.
No, that's fine.
Okay, thank you.
May it please the court, Jason Goldstein of Buckhalter here on behalf of Helvetica. Mr. Chad Messler of Helvetica is in the audience. I would like to phrase that the questions before the court are really twofold. The first is whether or not Geraudo is even a creditor having a lien by mortgage. I believe that is a dispositive question in the case that, once resolved, the court need go further to discuss the correct redemption price. But I will discuss that also because I believe when it is a junior lien holder redeeming from a senior creditor, it is more than the sales price, and the statutes flesh that out. To begin with, in order to be in the class of persons entitled to redeem, if you're not the judgment debtor or the assignee, you must be a creditor having a lien by mortgage. Here, Geraudo had a note, but he was not the beneficiary of a deed of trust.
Was his name on the deed of trust?
As lender, not as beneficiary. There's a holy trinity of people who have rights underneath a deed of trust that can exercise them. The borrower has rights, the trustee has rights, and the beneficiary has rights. For example, if there was a judicial foreclosure action brought under a deed of trust in which MERS was the beneficiary, if MERS was not the owner of the note, it would not be able to proceed forward.
Reverse show me the note argument? Because I thought we had finally flushed the show me the note theories out of the system.
This isn't a show me the note argument, Your Honor. It is more as who is a beneficiary, meaning who is the creditor having a lien by mortgage. Here, if there was a mortgage foreclosure action brought by judicial foreclosure, you'd have to show that you both own the note and the deed of trust. If this was a non-judicial foreclosure situation, this is just an analogy, Your Honor, is that if under Arizona's non-judicial foreclosure statutes, the ones who could notice it are the trustee or the beneficiary. Those two have the ability to do it without showing the note. If you're not one of those, you don't even have statute authority to even bring a non-judicial foreclosure, so there's just no...
This is a world in which we're not participating, so let's focus on judicial foreclosures, okay? I mean, we're talking about redemption statutes in the way that take effect in the wake of a judicial foreclosure sale, yes?
Correct, Your Honor.
Okay. So let's stay there. The analogies between non-judicial and judicial, I think, are dangerous because they were designed to be such different systems.
The point I'm trying to make from that is, in order to you can be a creditor. If you have a note, you could be a creditor. If you have a credit card, the Citibank is a creditor. It is not a creditor having a lien by mortgage. And that's the distinction I'm trying to make here. Geraudo had a note. He was not the beneficiary under the deed of trust. Therefore, he was not a creditor.
You're saying he had an unsecured debt?
Without him being the beneficiary, it was, Your Honor.
Okay, we take your position.
Okay. And it would have been easy for Geraudo to comply with the statute. He could have, one, had MERS redeem and provide the money, or two, he could have had MERS assign the deed of trust to him, and therefore he would have been a creditor having a lien by mortgage. I just wanted to address that point, and then I will now go to the fact of why a junior lien holder's redemption price is different than a judgment debtor. Public policy has found, and the legislature has found by creating these redemption statutes, that a judgment debtor is provided with certain protections after a judicial foreclosure sale.
Let's define our terms. When you say judgment debtor, what kind of a judgment are you talking about?
The borrower, a judicial foreclosure lawsuit under a deed of trust or mortgage.
Okay, that's a little bit different, though. We have to be careful when we talk about judgment debtors, because these statutes talk about judgment liens, and judgment liens have specific definitions. It's easy, I think, to just say the judgment debtor is the person who got sued, but that doesn't necessarily mean that you have a judgment lien in play.
I agree with Your Honor.
Okay.
What I mean is that the redemption statutes are designed, as it relates to foreclosure under deed of trust, to protect borrowers from unfairly low deficiency judgments. Therefore, the legislature has given borrowers subject to judicial foreclosures two options. One, they can exercise their right to a fair market value determination, in which case the bid at the sale is not going to necessarily reflect the amount of the deficiency judgment. Or two, the borrower can redeem after the foreclosure sale.
And when a fair market value determination is exercised, the effect is, correct me if I'm wrong, that if the fair market value was less than the amount of the debt, but more than the amount of the bid, then the deficiency judgment is adjusted to reflect the fair market value. Is that correct?
Absolutely correct, Your Honor.
Okay. Go ahead.
And so, in the statute dealing with the fair market value determination, 1566, and in particular paragraph C, the statute goes on for about 10 lines about what's going on with the fair market value determination, and once that's done, that the judgment debtor loses its right to redeem. But then it specifically provides that creditors having a junior lien to the lien foreclosed may redeem by 5-day successive periods as provided in section 12182 subsection C. And it basically says at the end of that, the redemption price shall be calculated on the sales price of the real property. As this court noted earlier, it easily could have said the redemption price is the sales price, but it didn't. Instead, it incorporated another statute which specifically provides that in order to redeem, you have to pay the lien held by the person from whom you're redeeming, and that's Helvetica. And I think that's the critical distinction on what the actual redemption price is for a junior lien holder.
So is it your position then that the amount needed to redeem in this case is the amount of Helvetica's original loan, or the amount of the deficiency judgment as reduced by the fair market value determination?
I believe it's the loan, Your Honor, but in any event, the redemption amount would still be incorrect under either amount, because $432,000 is not either the $3.4 million, nor is it the approximately $2 million.
But why should Helvetica then get the benefit of lowballing a bid rather dramatically, and the full value of its loan, none of which has any bearing on fair market value, and transform the redemption into a profit? I don't see anything in the statute that expressly says that, and I can't imagine why the legislature would have intended such a result.
Well, Your Honor, there are many reasons. First of all, for the amount of the bid, the decline in economy, the effect of bids on insurance, waste claims, appraisal claims. But in any event,
No, I'm not faulting Helvetica for making the low bid. It made it. It got the property. Congratulations. But now, if it wants to add that low bid to the original loan and ignore the fair market value determination, that seems to run afoul of the statutes.
Your Honor, if the correct redemption price is the fair market value determination, I would be fine with that as well, because in either event, the amount of the redemption price was still wrong. However,
But we're
I
not
believe
negotiating here.
No, I understand.
I want to explore the statutory language.
I believe the statutory language is that when a junior lien holder redeems, they have to pay the amount of the lien that the person who from whom redemption is made, which is Helvetica, and that's in conformity with the laws of lien priority. When a junior lien holder makes its decision to fund a loan in a junior position, it has two ways to protect itself. One is by underwriting the loan to make sure that there's sufficient equity in the property to protect itself. Two, it could bid at the sale. If it doesn't bid at the sale, if Geraudo had gone to the sale and bid 1 penny more than Helvetica, it'd be the owner of the property, and he wouldn't have had to deal with the redemption issue.
Isn't there another component that they weren't even noticed they weren't even sued in the foreclosure action?
They were not included in the foreclosure action, but there's no evidence that they weren't provided notice of the sale. But in any event, the redemption statutes do not provide a windfall for a junior creditor in order to redeem the property without having to pay the lien ahead of it.
But nor do they provide a windfall for the lender. I mean, let's go back to subsection C again. The redemption price shall be calculated on the sales price. How many at the legislature, you said the legislature, could have said shall be, it doesn't say be the sales price, but conversely, the legislature didn't say shall be the amount of the outstanding debt of the creditor. I mean, they could have easily said it shall be the amount of the outstanding lien. Why did they even say sales price? Calculated on the sales price.
Because this entire section deals with the fair market value determination, and so the legislator wanted to make clear that on the redemption price, it was not the fair market value determination. That's why it made clear in this last two sentences. Everything but the last two sentences deals with the fair market value determination. The last two deals with redemption, and it refers back to section 121282, subsection C, which specifically says in order for a junior lien holder to redeem, they must pay the amount of the lien of the person from whom redemption is made. And that's Helvetica. So it brings you back and it clarifies that the amount is not the fair market value determination, but instead is calculated on the sales price and takes you back.
So let's do a little math together using rough numbers, okay? If the credit bid was $400,000, the loan, let's say, was $3.4 million, and the fair market value was $2.2 million. Is the value of the lien post-sale $1.8 million? What is the value of the deficiency judgment after we take all of those numbers into account? Because as I'm conceiving it, it's about $1.8 million.
Well, there's going to be a trial next month to determine what the deficiency amounts, Your Honor, are, and so it's a convoluted number.
Give me your position. I know it's more convoluted than I've laid out.
Well,
Cover the big milestones in the calculation.
Well, in the initial Helvetica v. Pasquan case, the Court of Appeal reversed the deficiency judgment in the amount of $2 million, which took into account the fair market value determination, and instead basically said a portion of the loan was somehow purchase money, and you could trace everything back to what's not purchase money. My position is $600,000 is the purchase money, and everything else is deficiency. How that's going to relate to the fair market value determination, unfortunately, is going to be a tricky issue for both of us and the trial court. But in any event, I think the direct language of the statute is a junior lien holder who made its loan with full knowledge of a senior lien is required to make the creditor whole. The redemption statutes, as it relates to creditors, as redeeming later on, requires that the consensual liens be paid before a junior can take effect, just as if it would in any other situation.
Sure.
Counsel, can you go back to ARS 1282, that subsection C that you referred to a minute ago? And it's the last line that discusses the price. It says, last two lines, may redeem by paying the amount for which the property was sold in all lines prior to his own held by the person from whom redemption is made. How does this even apply in this case? There's no Geraudo was not redeeming. They're not paying somebody from who's already made redemption.
They're redeeming from Helvetica. Helvetica was the owner of the property.
That's not what the statute says.
It says, and paying all liens prior to his own held by the person from whom redemption is made.
Okay.
And therefore, a junior who's redeeming has to pay the amount of the
You're
lien
saying
from the
this
redeemer.
applies to, well, I guess I was confused because Mr. Klobuchar talked about A, B, and C. Like we had creditors A, B, and C, all junior lien holders. You're saying this exact formula applies to A, B, or C. It doesn't matter which one.
Correct. If A is Helvetica who forecloses and purchases the property, B would have to pay Helvetica in order to redeem, having not bid at the sale, regardless of the pros or cons with that. But yes, because under the whole law of lien priority, junior lien holders enter into the transaction knowing full well what's ahead of them. And the statutory scheme provides that creditors are to be made, consensual lien holders are to be made whole when junior lien holders attempt to redeem. And so I think that goes exactly towards our point, because the person from whom redemption is made is Helvetica, and Helvetica had a lien prior to Giraudо's, and therefore that had to be paid.
Well, that had to be paid, meaning whatever it's worth has to be paid, right? Not its initial face value.
Correct. The amount of the lien as it stood at that time, the amount due and owing to Helvetica, which is the amount of the lien.
As affected by other factors like fair market value, anti-deficiency, etc.
I don't believe so, Your Honor, because I believe, but in any event, the amount of $432,000 wouldn't have been enough to be the correct redemption price under any analysis.
I know. I'm moving past that
Okay.
to figure out what the correct redemption price is. And so there's the face value of the lien, which is the initial value of the unpaid loan. But a lot of water's gone under the bridge since then. There's been a foreclosure. There's been a determination regarding anti-deficiency laws. There's been a fair market value determination, and I'm sure a bunch of other relevant facts that I haven't mentioned. But all the ones I have mentioned seem to affect the legal value of Helvetica's interest at this point, right? Because after the fair market value determination, the extent to which Helvetica was secured was determined. Yes?
Well, I don't know if it would be the extent to which they were secured as opposed to the credit that the Pasquans were entitled to receive to any deficiency judgment. I mean, if the appraised value was the $2 million or something that was the fair market value determination, and we're saying the $4 million had to have a break of what was actually secured versus being oversecured.
Okay, but then we get into the question. I can see your analysis. You're saying that the fair market value is a credit toward the deficiency judgment, but the remainder of that deficiency judgment is not a lien on the property. Otherwise, the fair market value determination really means nothing, because the property is still encumbered to a degree that doesn't reflect the foreclosure action that happened.
Well, it reflects the foreclosure action to the extent that a deed of trust has been established, the amount secured by it and unpaid, as opposed to in comparison to what actually is the value of the property and security. I think that's the issue where I don't think being clear or truly understanding the court's question, so I apologize as far as that's concerned. But I agree, the fair market value determination should have meaning. However, it appears on my reading that doesn't go into the calculation of what the redemption price is for a junior creditor. Although I could see...
think you agreed earlier, though, that the fair market value determination affects the value of the deficiency judgment.
It does, but that only relates to the borrower and not to a junior creditor. But why should the lender ever get more than the outstanding deficiency judgment? I'm under any statutory scheme, I can't see that the legislature would have contemplated that you have a specific number out there, and I don't know what it is. I mean, there is a number by which you are owed money by the defaulting party here, the person who defaulted. You're owed money by Pasquan. They defaulted on the original note, correct? They defaulted, they were foreclosed. You are owed that amount of money, and that comes down because of the fair market determination value. The fair market value determination, the court has to lower that amount. Oh, you can't get, you being Helvetica cannot receive more money than that. So why should they be able to get it at other ways?
Well, for one, the lender would get the property, and then a deficiency judgment is lower. So it's not like there's a double recovery here. Here, in the redemption situation, we don't get the property. We would just get what we're owed. We're not getting anything more than we would be entitled to, and what a junior lien holder would have to pay in any situation. Let's say Geraudo had foreclosed. He would take the property subject to the Helvetica deed of trust and had to pay us in full in order to avoid having to be subject to us. So,
Well, of course, the easy way to avoid that consequence is by not lowballing the bid.
and I mean, the term lowball has been used, but there are various other factors that go into what the bid could be.
I think it's safe to say that even in the Great Recession, if you pay something approaching 10% of the value of the outstanding balance, that's pretty low.
I mean,
What also depends on
argument's
the-
sake, if it would have been paid $2 million, which is close to the fair market value determination, do you think we'd be here arguing this case? I doubt it.
That may be so, but I mean, that is, I would say, irrelevant to whether or not the correct redemption price was used, or whether or not Geraudo even is in the class of persons that had the ability to redeem. And just to quickly hit on my cross appeal, looking at the deed of trust, it specifically says MERS is the beneficiary. You have to be a creditor having a lien by mortgage. Anyone looking at that would have reason to know that holding a note is different than having a lien by mortgage. They're two separate things. And the Hogan case explains that, which I cited in my papers. And so I would respectfully request that the trial court's order denying our summary judgment motion be reversed due to the fact that anyone would have reason to know that he was not a creditor having a lien by mortgage. And my time's up. I'd be happy to answer more questions or just take a seat.
Thank you.
Thank you.
Thank you.
Thank you. I want to go back to subsection A of section 121566, which is execution statute that I think we all agree applies here. Maybe we dispute what that means. Subsection A says, this section applies to execution upon real property under a judgment obtained pursuant to ARS 33725, that's the mortgage statutes, or obtained pursuant to section 33814, that's the deed of trust statutes, or obtained against a guarantor or any other person directly or indirectly contingency liable on a debt for which a judgment under 33725 or 33814 may be obtained. So by definition, 1566 applies to judicial foreclosures of a mortgage or a deed of trust, not judgment liens, but a deed of trust or a mortgage, the consensual lien. That's what 1566 says, and 1566 is limited to deeds of trust and mortgage foreclosures by definition in subsection A.
No, I think the judgment lien problem comes in 1285B, not in 121566.
Well, right, but I want to point out that what the statute says is it says under a judgment obtained. So by statute, the legislature here is talking about this section applies where there's a judgment, and that's a judgment lien. I think they mean one of the same for this purposes, because it references a judgment obtained at the foreclosure, the judicial foreclosure of a mortgage or deed of trust, like we have here. So these statutes reference the judgment that's obtained, and that's the judgment that orders the foreclosure to be performed by the sheriff's.
Right, and that judgment is not a lien. That judgment is an order to sell. It's no longer a lien. There's a sale, and there's basically an unsecured deficiency judgment against the debtor.
Your Honor, I respectfully disagree that judgment is a lien. It's a lien which is a security interest against the real property that's being sold. The judgment lien is identical in the amount that's owed for the deed of trust, because when you get a judgment, as in here, the mortgage foreclosure states the amount that's owed under the deed of trust is and that's stated in the same judgment, and this is the case here, states the amount that's owed and orders the sheriff to sell the property free and clear of all interest of everybody else that's been named in the lawsuit. And what the judgment creditor obtains then is the title to the property via a sheriff's certificate, sheriff's deed, free and clear of all liens. There is no deed of trust anymore. There is no judgment lien anymore. The judgment creditor, like Helvetica, obtains title to the property, free and clear of all liens.
A third party buyer would also obtain it free and clear of any lien by Helvetica.
Exactly.
Yeah.
Exactly. Subject to
But
redemption rights.
It's not really a judgment lien, because it no longer attaches to the property. The the lien is realized and effectively extinguished by the sale to whomever.
Yeah. And the point I wanted to make, Your Honor, is, and I agree with that, but the point I want to make, Your Honor, is the same statute, 1566, that applies to mortgages and deed of trust foreclosures, states that once a fair market value application is filed, the judgment debtor has no redemption rights. And in the last sentence, in the statute, only applying to mortgages and deeds of trust, states the redemption price for junior creditors, the redemption price shall be calculated on the sales price of the real property. And I understand your problems with the words calculated, but if the legislature didn't mean that the prevailing bid price controls the redemption price, those words wouldn't be used. It would just say a junior creditor, because we're only talking about a situation where there are junior creditors to a mortgage or deed of trust foreclosure when we get into 1566.
Well, don't you calculate it based on the sales price, because the sales price ultimately affects the value of the remaining interest?
No, Your Honor. And I think if I can, in my short time that I have, hope to dispel you of that, there is no remaining interest. The value of the property for fair market value, the amount of the deficiency has nothing to do with redemption. May have something to do with the equities involved, but has nothing to do with the redemption. Once the foreclosure is held and the sheriff issues the sheriff's deed, title ownership goes to the foreclosing deed of trust holder. You now own the property, subject to redemption rights, but there is no deed of trust anymore. That's been foreclosed on, along with everything else that's been named in the lawsuit, is gone, extinguished, subject only to these redemption rights. There is no deed of trust anymore,
Correct,
and I believe Price does say that.
But the value of the lien that the 1285 requires the debtor or the redemptioner to pay is affected by the sales price, right?
It's controlled by the sales price. I mean, it states that quite clearly that the amount is to be paid is the amount of that the property was sold for at the sheriff's sale. That controls. That's the starting point for everything. And we've got to get past the idea that this deed of trust still exists because it's foreclosed. The deed of trust is foreclosed, and I believe that's why 1285 says, other than the judgment lien, it's referring to the judgment of the order from the court directing the sale of the property.
Well, thank you.
Thank you, Your Honor.
This has to be the most celebrated house in Arizona legal history. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.